Welcome and thank you so much for being part of this webinar today. I acknowledge the traditional custodians of all of the unceded lands that we're joining from today, and I'm joining you from the very beautiful lands of the Awabakal people. My name's Kate Davies and I'm the Research Director at the Law and Justice Foundation of New South Wales. Our purpose at the Foundation is to contribute to the development of a fair and equitable justice system. And one of the main ways that we do that is through research, and that's to better understand access to justice and contribute to an evidence base to inform impactful policy, legislation, practice, services, and systems. It's wonderful to have such a diverse range of people online today, and we've been really thrilled at the response to this webinar invitation. We've got practitioners, policymakers, researchers, and advocates from government, community, academic, and legal sectors across New South Wales and beyond, actually. I'm also really not surprised that there's such interest in this topic. Tenancy matters are incredibly impactful for everyone involved. The stakes are really high. We're talking here about people's homes and all of the hopes, anxieties, commitments, needs that relate to living in a home and also to owning a home. This is particularly pertinent, I guess, in a time where there are such housing shortages and a high cost of living. The outcomes of tenancy matters at tribunals can really change people's lives. But what we're focusing more so on today are not the outcomes, but people's experiences within the processes and how we, as such a diverse and committed group of individuals and organisations, can contribute to fair and just processes within tenancy dispute experiences. So in today's session, we'll commence with an overview of the Foundation's recent research on tenancy disputes, and that's going to be presented by Dr. Kerryn Butler, who's one of our principal researchers and was the lead of this research. I also acknowledge our fabulous co-researcher on that project, Dr. Emily Kofi, who's online today. We'll then hand over to Leo Patterson-Ross, who's the CEO of the Tenants Union of New South Wales, to provide a bit of an overview of advocacy and advice in the context for tenancy issues. Leo will then be joined by our other wonderful panellists, Emma Maguire, who is a tenant advocate with Mid-Coast Tenants Advice and Advocacy Services, and Julie Cleary, who's a training major with Community Housing Industry Association of New South Wales. After the panel discussion, there'll be a brief opportunity for you to ask some questions of the panel. And so you'll see in the top right-hand corner there's an icon to join. So click, and then you'll see a space to enter your name, pop your name in there and click Join Audience. And then you'll be able to click on Q&A and enter your questions. Apologies if we don't get to all of the questions today. An hour is pretty brief to squeeze such wonderful and important content in, but we do really encourage you to follow up with us if you still have questions or things you want to chat about after the webinar today. So I'll introduce you now to Kerryn Butler, who's going to share some of our recent research highlights. Thanks, Kerryn.
There's two studies that I would like to speak to you about today on tenancy dispute resolution. And to start with, there's a big thanks to my co-authors Kate and Emily, and of course to NCAT, who shared their data with us and allowed us to take a peek behind the registry curtains, so to speak. These two reports were undertaken by the Foundation with the intention to inform, in part, DCJ's review of NCAT's tenancy lists. The Data-driven Insights report provides the system-level picture, nearly 40,000 tenancy applications finalised last year, and this helps us to understand how the tribunal functions procedurally, who applies, how matters progress, and what types of outcomes are recorded. The STEP study complements that by stepping into the lived experience of people who come before the tribunal. It captures what the day feels like, how prepared they felt, how they experienced conciliation, and how they perceived fairness. When read together, these studies seek to illuminate where the system works well and where users encounter some friction. This provides a basis for improving fairness and accessibility across the tenancy system. So, tenancy disputes in context. So, the administrative data gives us the system level picture, which is discussed in the Data-driven Insights report. In 2024, nearly 40,000 tenancy applications were finalised, and the majority of these were brought by landlords. Most matters are resolved within 6 weeks, which shows NCAT's efficiency and accessibility at scale. A quarter of the matters were resolved by consent orders, so negotiated agreements recorded by the tribunal. These are particularly common in social housing, where special performance orders and the housing providers use these to support tenancy sustainment through agreed repayment or compliance plans. About a third of the matters were withdrawn or dismissed, and sometimes because parties resolve these issues informally, and sometimes because of procedural or engagement barriers. Unfortunately, the data sheds no light on which of these it most often is. So these figures demonstrate an active and efficient tribunal, but what they don't tell us is how people actually experience those processes, how prepared they felt, how safe or confident they were in conciliation, and what fairness meant to them. And that's where the STEP study helps to fill that gap by bringing the human perspective behind these numbers. So, conciliation is central to most tenancy disputes and how they're resolved at NCAT. So, as I said, roughly 1 in 4 matters end in a consent order, meaning that the parties reached agreement through conciliation. So, the intention of conciliation is positive. It's to provide a quick, low conflict path to resolution. And when facilitated and supported well, it can achieve that. Participants in the STEP study described conciliators and tenant advocates as essential in helping them understand options and feel supported. But the study also found wide variation in practice. In some locations, users were asked to negotiate without a trained facilitator present, effectively left to negotiate alone in high stakes and emotional settings. And importantly, consent doesn't always mean the outcome felt fair. Some participants accepted agreements they didn't fully understand, often because they feared losing their housing or they felt pressured to settle. And these findings don't suggest that the conciliation model is failing. Rather, they show that consistent, skilled facilitation and early access to advocacy and support are essential in ensuring that conciliation can deliver both efficiency and fairness. And it's also where power dynamics have a significant effect. So, not all parties are equal. And these power imbalances between parties are pretty obvious. The tribunal model of self-representation is central to putting law in the hands of the people, but it often assumes a level playing field for users. And the reality is quite different. Tribunal systems are built on the premise that most people can represent themselves effectively, yet there's surprisingly little evidence about what level of legal capability that assumes, or whether most users might have that. Our findings suggest that people's capacity to self-represent effectively is situational. It depends on how their knowledge, confidence, and available support interact in the context they face. It's not on confidence alone. We also know from recent research from Victoria Law Foundation's Pulse findings that legal capability is unevenly distributed across communities. Landlords are overwhelmingly represented by their agents and are repeat players. They're familiar with NCAT, with the Tenancy Act, and with how to present a case. Tenants, by contrast, are typically first-time users. Many arrive anxious and unfamiliar with their rights, and they may fear being blacklisted or evicted, or they may not feel safe asserting their position, especially if the process is rushed or unsupported. And yet, the process treats both sides as though they are equally capable and confident of navigating it. These differences in familiarity, preparation, and power shape how people experience fairness, even when the same process is applied. So, what the day feels like. For many tenants, attending the tribunal is not just unfamiliar, it can be daunting. They arrive with limited understanding of what's going to happen or even what conciliation involves. It can feel like everyone else, especially agents and tribunal staff, is part of a system that they don't understand. Some told us that they didn't know where to go, when to speak, or even whether their matter had been finalised. And despite NCAT's aims to conduct proceedings as informally as possible, many participants told us they felt intimidated and anxious. Tenant advocates play a critical role here. Their support can make the difference between a tenant engaging meaningfully or withdrawing under pressure. But not everyone has access to that support. Participants told us tenants advocates gave them confidence, helped them follow what was happening, and provided reassurance in a high-pressure setting. There's also a mismatch between how the schedule is structured and how long things actually take. And this adds further stress and uncertainty and pressure to agree quickly. So matters are listed in groups on the hour, which leads many tenants to assume that their case will be dealt with within that time frame. And in reality, things often run much longer, with parties waiting to be reslotted into later groups. And for tenants who are juggling work or childcare or even just parking, this just takes stress to a whole nother level. We also wanted to know what fairness feels like. So these structural and emotional dynamics shape how people perceive fairness. Tenants are often negotiating against landlords' agents who are confident, familiar with the system, and they're there as part of their job, while the tenant might be under the threat of eviction or housing loss. And communication matters. When people don't understand what's happening, or they feel rushed or unheard, it undermines their trust in the process, regardless of the outcome. Participants told us it wasn't just about the outcome, whether they won or lost. It also mattered whether they felt heard, respected, and able to participate. When the process was clear, even difficult outcomes were more acceptable. Experiences of conciliation were polarised. Some found conciliators invaluable. They stepped in to de-escalate and support agreement. And others described them as biased or disruptive. And when conciliation happens without a neutral third party, it can feel unsafe and very unfair. Even when outcomes are recorded as consent orders, tenants may not feel that they had a real choice. So these findings show that fairness is not just about the decision, it's shaped by every step of the process, from waiting in the lobby to hearing the outcome. So what can be done to strengthen user experience and trust? And this is what participation feels like. The tribunal model is built on accessibility through self-representation. The idea that with simple procedures, most people can manage their own case. But that model assumes a baseline capability, the ability to understand information, prepare documents, and advocate for oneself. And not everybody starts with that. We saw that capability varies widely, shaped by things like literacy, confidence, and stress. And that's where advocacy and support become essential. Tenant advocates in particular help turn self-representation from a principle into a reality. They make participation possible for people who might otherwise disengage or agree to things that they don't understand. And finally, fairness is not just about what happens on paper. It's about what the process feels like, whether people feel heard, respected, and supported along the way. And that's what defines justice in practice. So you can find both of these reports on our website, but it's important to hear directly from key players in this space. So I would like to introduce Leo Patterson-Ross. Leo's the CEO from the Tenants Union, and he's here to share a little bit about the role and reach of the Tenants Advice and Advocacy Program. Thank you, Leo.
Thanks so much, Kerryn and Kate and all the researchers at Law and Justice Foundation who done this report. And it was such a gratifying report really to read, because it reflected the experiences of renters as told to this independent third party. We had nothing to do with it, and it showed how important tenant advocates are. So the Tenants Advice and Advocacy Program is a network of 19 services, on the ground services, that are supported by 2 resource services. So 21 individual organizations across the state. We operate in 2 streams. There's 15 general services who have geographic coverage of the whole state, and 4 Aboriginal run and focused services that also have geographic coverage of the whole state between them. And the Tenants Advice and Advocacy Program has been running for 30 years. It had a earlier predecessor, but this current iteration is 30 years old, and it is actually funded by statutory interest accounts, the Rental Bond Board, and sometimes historically the Property Interest Account. So essentially, it is the sector the property sector funding itself, which is a really neat model. Not everybody knows as well that the tribunal is funded from the same source. So both Tenants Advice and Advocacy Program and the tribunal receive funding from this industry pool of money. And that means that there's really a nice link here between particularly tenants' bonds and their access to justice. And we really need to make sure that these things work in tandem. The Tenants Advice and Advocacy Program operates at a range of levels. We may be most well known actually for the website that the Tenants Union operates, which is visited by 700,000 plus people a year seeking information about their tenancy rights. And for people who then need more assistance, they will get in touch with the local on the ground Tenants Advice and Advocacy Program. And we talk to about 40,000 people, 35 to 40,000 people in a year, about a variety of tenancy issues. Some that might end up going to the tribunal, others that can be resolved without the tribunals, without accessing the tribunal. And that's very personalized advice that depends on the particular circumstances, what somebody's facing. Of that, then about 5,000 people are represented by tenant advocates in the tribunal each year. And so that represents about 10% of the tribunal cases around tenancy. There is a tenant advocate involved. And so that gives you a sense of the people who aren't directly represented. But many of the people who are self-representing in full may have been in touch with the Tenants Advice and Advocacy Program service in their area, or through the website, and gained some information. And we will always be looking at ways to see how much people are accessing that information. But when we are directly involved as tenant advocates in a case, it certainly also doesn't start at the tribunal. The Tenants Advice and Advocacy Program has a real focus on trying to resolve issues sort of as easily and painlessly as possible. And that might look like negotiating and reaching out, trying to negotiate an outcome, a repayment plan, the repairs to be carried out, the bond to be returned fairly before the tribunal. And sometimes that's with an advocate reaching out on behalf of the tenant. Sometimes it's with support for the person to reach out. But we also sometimes find people at the tribunal. We run duty advocacy in many of the registries around the state, where people will come on the day without prior connection with their local tenants advice service, and the duty advocate will do their best to assist. Again, that is a small proportion of the full number of cases that go through, but it's a really important part. And I will just call out that there has been a recent development in the tribunal of an Aboriginal tenancy list, which runs off that duty advocacy model, but with a lot more support and many extra support services in the available to participants in the list, which has been really powerful. It only started right at the end of the research period here, so couldn't be pulled in, but it's a really interesting and useful development. So a tenant advocate is essentially trying to rebalance that kind of power imbalance, that uncertainty, that lack of confidence that the research pulled out, whether it's through knowledge or education or through taking up action on behalf of the person. At the end of the day, what we're really trying to achieve is pulling those two parties back into a more even alignment and giving people the chance to have their case heard, to present the evidence, to present their story and their experience for the tribunal to hear and adjudicate whatever dispute is there, as well as finding both legal and practical solutions to the dispute, because we do recognize that the law itself is not always the best answer for what may be in dispute. We do cover the whole state, and there are differences in the experience that advocates see. And one of those that really comes strongly through is the consistency of conciliation. Many regional advocates say, what even is a conciliator? We don't see that around our area. We also have different travel considerations. If you're in a city, particularly in Sydney, but also Newcastle and Wollongong, your travel time to the tribunal may be reduced. But if you're out of town, and increasingly we saw a reduction over COVID of the number of operating registries, and during the middle of COVID, a greater reliance on video hearings, but subsequently inconsistent approach to video and in person. We had heard stories from people who had to get up at 3 or 4 a.m. to start traveling to make their 9 a.m. hearing. And that obviously meant that they arrived exhausted, tired, and feeling very much more of a struggle to make their case. So there are definitely accessibility and consistency across different regional areas that people can find, and advocates can also play a role to even that out, because the advocate may be closer to the tribunal, may be able to act on the person's behalf, may be able to help file paperwork, and that's a service that the service can deliver. But sometimes we've also seen changes in the structure. So particularly with the move to the online listings and the portal for making applications, that actually some tenant advocacy services were excluded from that and weren't able to continue providing the same type of service to clients. So, the tenant advocates are come from a range of professional backgrounds. There is a mix of legal practitioners as well as social workers and community sector, but fundamentally we are here to try and support renters through this process and find the tools and the ways of working that will best to support them through the accessing their rights, making sure that these disputes are resolved as fairly and as quickly as possible. Thanks, Kerryn.
Thanks so much, Leo. That was a really valuable overview of the work that the Tenants Advice and Advocacy Program does and the scale of support provided to renters across New South Wales. We've now looked at the data and heard what it feels like for people who come before the tribunal. And Leo, you've just reminded us of the critical role advocacy plays in helping tenants address tenancy issues, including tribunal use. But to deepen the picture, I'd like to bring in our other panel members, and they will each be offering a different perspective on what fairness and capability look like in practice. So joining Leo, we have Emma Maguire and Julie Cleary. So turning first to you, Emma, from your work with tenants, how did they describe their experiences of tenancy disputes in general and of NCAT more specifically?
That the experience is often one of frustration, unfortunately. they'll talk to us about, this is outside of tribunal, not being listened to, poor communication, say from landlords and agents, not being treated with respect, no attempts to have a meaningful sort of discussion to resolve disputes. And overall, I think a feeling of the system is not fair for tenants. So I think predominantly, though, it's really the tenant experience of a dispute arising in their tenancy is one of fear. So that's often what people will talk to us about, that they are afraid that where disputes escalate with their landlord or where they try to enforce their rights, that their tenancy may be at risk. That's, renters still fear eviction above all else, even though we're now in a post no grounds eviction sort of world. They still overwhelmingly are afraid of being evicted and potentially being homeless. The thing that we hear probably more than anything else is around, that they don't want to rock the boat. Every tenant advocate will have heard, I don't want to rock the boat. So they'll call us for help, for advice on their rights, which is a really important, sort of first step. But we might give advice around, you could take this to NCAT, but they are afraid that if they rock the boat, they may be evicted. And that's just sort of the thing that is running, behind the scenes that underlies like the life of a tenant, I think, is you don't have security of tenure and people are afraid of being evicted. So I think that's sort of the experience generally and the feeling for tenants. Inside tribunal, I think so much, which I think this is touched on in the research, like so much of the feedback we get from tenants who go to the tribunal is that the experience really depends on the member that they get, the tribunal member they get on the particular day, because different tribunal members go about things in different ways. And tenants often may say, they went to tribunal, they didn't feel like they had their opportunity to say their piece, that they, again, perhaps didn't feel like they were treated with respect at tribunal. And so those things are just sort of, again, similar experience that they perhaps have with their landlord is then replicated at tribunal, unfortunately. Whereas some tenants will say, I went to tribunal and it was a good experience because perhaps I was supported by a tenant advocate, so it made it an easier experience. But that they felt the member was fair. So there can be a big is a difference in how people perceive NCAT depending on, I think, the member on the day. And I think there's also a big disconnect often with tenants at how they think NCAT will run and how NCAT actually runs, because some will make an assumption of, when I get into NCAT, NCAT is going to hear everything that has happened in the tenancy and I'll be able to raise every issue that has come up and sort of get a resolution on that. Whereas unfortunately, that's not how NCAT will work. They will be dealing with what is on the application. So the issue that's subject to the application, which perhaps is, often a landlord application for, say, a termination eviction. So that's what the tribunal would be looking at. They wouldn't be looking at, unfortunately, that there's outstanding repairs or that the landlord's been showing up without giving proper notice. So there can be frustration with that, which sort of ties back to inexperience in the tribunal. Unfortunately, but ultimately, I think just tenants want to be able to tell their story, which is often why they call a tenant advocate to start with, because they want to share their story and feel heard. And they take the same approach to tribunal, that they want to go there and share their story and have it heard. But it's not always that simple or straightforward, unfortunately. But otherwise, we hear a lot of the issues that are raised in the research around accessibility and a lack of plain English and people not understanding the processes or not being given clear directions, I think, or directions they understand by tribunal and things like that. But varies so much depending on the tribunal member on the day. You can have two tenants with similar matters that go before different members and will have vastly different experiences, even if the outcome is the same.
Thanks so much, Emma. That's great to hear. That really does reflect the findings from our study. Can you talk us through one or maybe two examples that stand out to you where you saw the difference that having an advocate made to a tenant?
Yeah, sure. Look, so many cases. A couple that come to mind. We had one a little while ago with a tenant that we'd encountered at duty advocacy, who was in quite significant rent arrears and was facing a termination of their tenancy and potentially homelessness. Was, as many tenants do, showed up to tribunal in quite an emotional state. So it's very, a very upsetting sort of process that the tenant had not been through before, and didn't necessarily know what to expect, and thought, that they were going to be evicted that day. So fortunately, there was a tenant advocate that was present that was able to help and explain the circumstances. And, a quite a vulnerable tenant in an especially vulnerable emotional state would have struggled on that day to put their case properly to the tribunal member and to know what was relevant and what to say. So in that case, there wasn't an agreement because the landlord wanted a termination of the tenancy. But a tenant advocate being there meant we were able to, solicit those important details from the tenant and sort of package them up in a way that we know the tribunal member will be helpful in front of the tribunal member, in a way that's relevant and is persuasive to the tribunal member. And even though in that case the tribunal member actually said, I'm inclined to terminate this tenancy because of the submissions that were made by the tenant advocate, the member used their discretion not to terminate in that case and instead ordered a payment plan. So, potentially without a tenant advocate there, the tenant would not have been able to make those arguments to the tribunal or to show evidence, to show, yes, I can now service the rent. I've got a new job and I can sustain the tenancy. So they potentially would not have been able to do that without a tenant advocate. So that's one example. I also had a more standard repairs one recently that I assisted with at tribunal for a social housing tenant who was, elderly. There's often a lack of access to technology, and a lot of people not comfortable with technology in our region. So was probably a tenant who would have struggled to navigate the process from start to finish herself. But because we were able to assist her with, okay, well, we'll write to the landlord for you, that didn't achieve what we wanted it to achieve. We'll draft the application for you to get it into the tribunal and give you help to lodge that. We'll attend the tribunal with you because fortunately we had capacity to do it in that case. And, it was a virtual hearing, which, as I think Leah sort of indicated, is a bit inconsistent at the moment. So we do have quite a number of virtual hearings. We were able to walk the tenant through how to engage with that virtual hearing and attend and ultimately get a conciliated agreement for the repairs to be done, which were quite significant and had been outstanding for a long period of time, and to get compensation and to get that put into consent orders. And afterwards, when we did a debrief, the tenant sort of said, there is absolutely no way I would have been able to do that myself if you weren't there, which, even though it was like, a fairly, as things go, standard sort of repair issue, that kind of brings home that even those sort of quote unquote simple matters are not necessarily easy for people to navigate. So potentially if we hadn't been able to assist with that matter, or the tenant hadn't sought advice from us, like perhaps the repairs would just never have been done because they had been outstanding a long time and she may have just let it stay that way. So actually, being able to assist that tenant from start to finish of that matter and actually getting the result that she wanted was great. And potentially without a tenant's advice and advocacy service involved, that would never have been done. And as she said, she wouldn't have been able to navigate that, unfortunately, herself if she was by herself. So that's a couple of examples anyway of what we do.
Thanks so much, Emma. That's great. Julie, I'm going to turn to you now. What are the responsibilities that community housing providers are trying to fulfil when they're involved in a tenancy dispute at NCAT?
They're trying to fulfill and to sustain tenancy. So I, as the training manager, deliver the training to social housing staff members, and the aim is to try and sustain the tenancy. So the use of NCAT is used because there may be some disengagement, there may be non-communication. Sometimes the only communication is effectively starting that process. So it's about using it in a tool to sustain tenancies rather than as a tool to end tenancies. And I think that's, again, shown in the data in relation to the specific performance orders and getting those in place to help with that tenancy and that tenancy to remain and move forward.
Thanks. Can you share with us what the challenges are that are associated with community housing providers being landlords, but also wanting to support their tenants?
Well, yes, I mean, obviously, as being landlords, they are there to obviously, receive rent, do visits, property care, like check properties and so on. But obviously, wanting to sustain those tenancies and work with tenants to help that, and referrals, and bringing in services to also assist tenants in sustaining their tenancies. But obviously, they do have a regulatory system that they are abiding by also, which they have to maintain as well. So there is that, I suppose, balance of managing the properties, managing the business, and also then managing tenancies and keeping those sustainable.
Great. Thanks so much, Julie. Across to you now, Leo. What changes at policy or systems level are needed to make the tenancy dispute process fairer?
Yeah, thank you. And look, I mean, I think you flagged some earlier. Making sure that people have access to the services that would assist them is a really key thing. But at some level, it is always going to be an intimidating process. It is always going to be an uncomfortable environment for people to try and engage with these sort of legal processes. And there's good reason for it to be a comprehensive decision making, because we are talking about very important issues. There needs to be elements of fairness, of rigor around looking at evidence and making a case. But we can also make sure that it is at a human level, that you don't need to feel like you have to have a solicitor or a barrister representing you, that you can engage with that process yourself. So advocates are a neat fit for that, and making sure that the funding is available to make sure that people are there, particularly for eviction matters. I think that stepping back before we get to the tribunal and thinking about the processes that have got a case to that point, and particularly in the social housing space, hear Julie's commitment, and it's one that's reflected. We hear it constantly from housing providers about sustaining tenancies, but we also have this experience of, from the tenant's perspective, they have often been served an eviction notice, which makes it sound like they are at real risk of homelessness. It may be triggering previous experiences of homelessness, but it may just be something that is very intimidating. And the structure of the application process, the structure of the law might push a provider to serve an eviction notice, to apply for eviction, even though they're actually only going to ask for a payment order. Mm-hmm. We should be stripping out that threat of homelessness, threat of eviction, and focus on the payment plan if that's the case. It's in the stats. We do see a really high overrepresentation of social housing, both public and community, than what the private market looks like. And certainly the private rental market is not a role model for anyone, but it does appear to be a problem area that we're not really treating the process of evicting a person with the seriousness that it needs, because of the potential impacts on renters. So we'd really like to see, for instance, a greater emphasis from the tribunal on asking a provider, a landlord who is seeking eviction, what have you done before now? What has happened before now? And maybe you don't get to apply for eviction without having already tried a performance order, as one example. I think that the way that the tribunal runs its business in the legislation, it says that tribunal members have a lot of discretion of how they choose to run a hearing. But I think the consequence of that is the sort of inconsistency, different approaches that people can feel, and having some better guidance around what to expect, the standards. And along with that, some better transparency. We talked about there's 40,000 plus matters made in the tribunal each year in the consumer and commercial division for tenancy. Only 13 of those decisions were published in the calendar year. That means that there is a vast number of decisions that are being made that nobody has any scrutiny over. And that's quite unusual in the sort of justice context, for people to be making quite significant decisions about other people's lives without that public scrutiny on it. And of course, we have to manage privacy of the parties and so on, but there is a great capacity there, which we think would encourage really improved decision making. Because if you know that someone will read it and critique your decision, you might put in a little bit more energy into how that decision is made.
Yeah, that's great. So there's lots of different solutions at different parts along the journey. Leah, who are the people in the groups that need to be involved if we're talking about some types of reform to make this process feel fairer?
So ultimately, it is everybody who attends the tribunal. The challenge for getting tenants' perspectives is, as you say, that they're often one-time users. And so I think that is a really important voice to make sure is heard to. Research like this is a great way to draw that out, particularly the STEP process, to talk it through with people and understand where the challenges and so on were. But for people who are more frequent users, the community housing providers, tenant advocates, real estate agents, and so on, then there is also a really great kind of potential there to draw out issues as they emerge and look at solutions. I do think, going back to the funding point, there is significant subsidy of the tribunal in its residential matters that's coming from the rental bond board, that's coming from the property services interest account, and we should be making sure that these funds that are generated from tenants' bonds and from tenants' money is being spent effectively, particularly when we look at things like the digital space and how that's being implemented, to make sure that government is also looking at it and has the ability to ask good questions about how it is spending its money.
Yeah, that's great. Thanks, Leo. We've got just a few more minutes before we open up to the audience Q&A. So I just have a couple of questions for the whole panel. And the first one is, what does it look like when processes work well?
Tenancies remain when the process works well, when it's early intervention. And I think, Leo, you've kind of touched on a lot of spots there. It's when you're going through the legal system and the thought of eviction or termination. And I think language is really important as well. When a termination notice is being received, how that's being received. So the termination is the process. The language used in relation to that termination makes the difference. It's not about terminating you. It's about making contact, and it's about getting this process back on track. So I think, like I said, the points Leo made and the work that they do in the advocacy space is really good. And I know that when I'm delivering training and explaining to staff members that advocacy is a benefit for tenants to know their rights and their responsibilities. So having that information relayed outside of the person that's making that termination, or starting those conversations in relation to which might be difficult topics. People don't generally stop paying their rent for no reason and things like that. Things are happening, and it's trying to get that information, and sometimes you can't get that as being that touch point and that tenancy manager. So having additional services in place is beneficial.
That's great. And what would it take to improve tenancy dispute process? I mean, we've talked a little bit, Leo, about who needs to be involved in these kind of discussions. But what do you think it will take to get everyone to the table together to start working on some solutions?
I think, well, we are in the process of, and we're waiting to see the results of an NCAT review where a whole lot of people did have the opportunity to have their say about the kinds of things that could be improved and that would address a lot of the concerns that the people have had and came up through this research. So look, as an optimist, we might hope to see some of these things already in a real chain to be addressed. I think at the end of the day, there does need to be a real commitment to a reform and reform cycle and looking for ways to improve. And sometimes that will mean more resources made available to the tribunal. The things like accessibility in regional areas, it is going to cost money to have a hearing held in places that are convenient for all the parties. That is a cost. We have to be realistic about that. And these AV hearings are not appropriate for everybody. So, physical hearings, there are parts of that will require some additional resources. But I think better and clearer guidance around what people can expect, making sure that that's a consistent and welcoming experience for people entering this quite intimidating space is very important. So looking at those processes, looking at the ways that the tribunal can communicate both to users of the tribunal and to its staff and the members about how to behave and how to run hearings, how to run requests for different kinds of information would be really valuable.
That's great. Thank you so much, Leo, Emma and Julia. It was just a really thoughtful discussion. We've covered a lot. So we've talked about from what happens inside a hearing room to broader systems and supports. I'd now like to open the conversation for the audience Q&A. So Kate, I'll hand over to you if you'd like to facilitate those questions.
Great. Thank you, everyone. And gosh, I think we'll all have questions pinging in our brains for the next few hours. Remember, those of you participating online today in the webinar, that you can click on that Q&A icon in the right-hand corner, and you'll be able to enter your name and join the audience. Then you'll be able to post your questions. Thank you to those of you who have started to put forth some questions. So we've had a couple of questions about access to hearings, and in particular, questions about the challenges for people accessing hearings in regional and rural areas. So Linda has noted some experiences of people being listed for a hearing in a location other than where they live, and some mixed experiences about audio-visual hearings, where they are available, where they aren't available. Do any of you have any reflections on whether and how can access to hearings, whether in person or audio-visual, has changed, and what that's like, the impact of some of those issues?
I can take that one. That might be
Thanks,
good.
Emma. Right.
Yeah, that's interesting. I saw Linda's comment there. I can't say that's an experience that we're having on the Mid-Coast, that we do see a lot of virtual hearings because we no longer have a tribunal member who resides in this area that we used to. So we used to have reliable in-person hearings, and now they rely on sending members up from Sydney most frequently, or Newcastle. Accessibility to the access to hearings is, just a key, right, fundamental issue. So that's quite concerning if they're listing matters really far away but not allowing people to attend remotely. Fortunately, we're not seeing that here. We see that if they're listing, say, Taree matters out of Sydney, which is quite common these days, those are all automatically virtual, so people can attend that way. They don't have to seek permission to attend that way. So that's concerning if NCAT is not allowing that to happen, because I'm no expert in geography, but Dubbo and Wollongong are fairly far apart. Just off the top of my head, so that's concerning. Yeah, that shouldn't be happening, which is obvious. But yes, there are various issues with access, and which might be tenants in quite remote areas have to travel into Coffs Harbour for the hearing, and actually NCAT doesn't always make it really obvious that people can request to attend virtually, so people don't know, so they might just not attend because they don't have the ability to get to the hearing. So yeah, certainly those things need to be improved to make it easier for tenants to attend remotely. But I think, as Leo said, I don't think just exclusive like virtual hearings is the answer either, because we do have issues with people don't have reliable internet or phone in certain parts of our community, so that is not necessarily a solution either. But yes, access, I mean, that's it, access to justice. You should be able to attend hearings to engage in the process. So always concerning if that's not being easily facilitated by the tribunal.
Yeah. I mean, there's been a strong message across all three experiences, Emma, Julie, and Leo, that you've described around the diversity of people's experiences and having opportunities for people to access in a way that works best for them is really important, for tenants and landlords, of course. Yeah. The Tamara has asked a question about whether tenants and advocates should be requesting a copy of written reasons more often. Maybe that's a simple one to answer. I don't know. Leo?
So I think Tamara's kind of responding to that point about how many decisions are published. And it used to be under the CTTT that requesting a written reason would prompt a more likely chance, and actually most of the time a written decision would be published. That doesn't seem to be the approach taken under NCAT. There is an assumption for appeal panel decisions to be published and an assumption against general division decisions being published, kind of regardless of whether written reasons are made. But in the appeal panel, it's just much more ordinary for a written reason to be published. We're certainly aware of times when people have requested written reasons and they haven't turned up in case law. So I think that it is a more basic question for the tribunal about how it will improve the transparency of the decision making.
Thanks, Leo. I might put the next question to you first, Julie, and perhaps reframe it a bit initially. So there's been a question about whether and how agents are cooperative when tenants advocates liaise with them. But I was really interested, Julie, in your reflections about the shared purpose around sustaining tenancy and some of the work that you do in your training to say, hey, it's great for everyone when someone has a tenant. But can you describe some of the responses and perhaps what it's like from that landlord end of things to engage with tenant advocates in the process?
I haven't had any feedback that it's been negative. It's always been positive because when there's generally, if there's a loss of engagement with the tenant, having tenant advocacy, and I think it goes back on some of the things that Emma and Leo have said, where the tenant may not feel comfortable in having those questions or starting those conversations. So having the tenant advocacy to kind of have that conversation and be that bridge between both the tenant and the landlord. Like I've been doing this training for a very long time and I haven't met one landlord that has chosen for termination as a first point. So communication is always the first star, and they offering the information for tenant advocacy for tenants to be able to go and have those conversations and trying to get more information around what's happening or the conversations that have begun. So I think it's a positive step, and I've only heard as a positive step on my feedback in my own personal training and delivery to housing managers.
Great. Thanks, Julie. And yeah, it's such an important reminder about the shared goals among everyone involved, right? The challenges, kind of how we get there and how we facilitate that communication and transparency. I'll pose one more question, and perhaps Emma, Julie, and Leo, you could each say something briefly about this. Tamara's asked a question about, additional considerations for social housing tenants, but perhaps even more broadly than that. What do we really need to consider when there are vulnerabilities or complex needs of people going through the tribunal process? Yeah, Leo, do you want to go first?
So I think you're right. I mean, there are a number of considerations that we need to make for a range of different people. And I think whenever you have a process that's sort of intended to apply to everybody, it can be easy for it to become unworkable for particular groups. I think some of the things that I would call out as particular considerations is the access to computers, to printers, particularly if physical copies are being requested, the familiarity with the kinds of evidence, the kind of documents that are being requested is often a challenge that people don't always keep every single letter, every single note that gets passed to them, with the idea that maybe they'll one day need it in a court-like process. So having also some clear supports from the social housing providers, who are generally the people creating these documents, to make sure that access to information is always available. Many providers do that, but it's not consistent, particularly once you leave the public housing space where there are different rules around, access to public information and administrative reviews. So making sure that people do have some and tribunal members have some consideration of the likelihood that evidence may not be presented in the most perfect way, and looking instead to the substance of the issue, trying to resolve it there, which again, that is intended to be the purpose of the tribunal. Many tribunal members do try and embody that, but the consistency is occasionally mixed.
Thank you. Julie, do you have any reflections on that? And, perhaps ways that you have seen social housing providers really support those kind of complex needs?
So in respect to what Leo just said, so best practice is to bring that third copy of everything rather than showing your copy to a tenant. Bring an additional copy of the tenant, or if they have asked for that prior, to giving them a copy of them to review before you even get to tribunal. I mean, there should be conversations, and when we're talking about individual groups, it starts with trying to build that rapport, trying to build that connection, and actually discussing what the issue is and finding out what's going on, because there could be tenancy managers that have a large number of tenants, and it may not flag straight away that there are some underlining or more kind of needs that need to be taken into consideration, and that's going to begin by those conversations. But like I say, in the training, we always say for best practice, you should bring a third copy for your tenant, because even you want to shift that power balance. You don't want to lay out your documents inside the conciliation room, because at the end of the day, that's a power balance of your documents. If there is a second set of documents for somebody to review and you go over together, it doesn't mean the outcome is going to be different, but that feeling of not being given something to look over and stood over in that respect. This is a copy for you to review. Let's go through them together, because that way that's for negotiation. That's where you're trying not to have that power balance in that room whilst you're doing conciliation.
Thanks, Julie. What a wonderfully kind of practical and tangible example of addressing those tricky power dynamics. And perhaps the last brief word to you, Emma, about how you support those complex needs.
Yes. Look, I mean, the social housing clients that we have can be some of the most vulnerable people that we encounter in our line of work. And, obviously somebody who has a social housing tenancy, if they are evicted from that tenancy, often they are not going to be able to secure or sustain themselves in the private market. So, assisting, we do prioritise social housing tenants who are facing eviction, because it's so important for people to hold on to their social housing tenancies. But I mean, I would love to see things like, additional training for tribunal members around, say, dealing with, trauma-informed practice around domestic violence, things like these, because, those are really necessary when they're dealing with vulnerable people in front of that come before them. So, I think that would go a long way. And just Leo mentioned the Aboriginal list, tenancy list earlier, where the tribunal has looked at, we can provide more support services and do things in a way that, better caters for the vulnerable people that are coming before us. So, I think there are things the tribunal could do to improve more broadly how they treat some of those vulnerable people that come before them. But yeah, additional training and perhaps more spaced out lists or things like that, so they have more time to deal with social housing matters, might be helpful too. So yeah, there's certainly work to do to make sure those people have as much support as possible to sustain their tenancies.
Thank you so much. Wow, what a panel. Thank you so much, Emma, Julie, and Leo, for really bringing some of the findings from that research to life. And thank you, Kerryn, for sharing that research in such an engaging and thoughtful way. And thanks to NCAT for being open to the experience of this research as well. And of course, we really want to acknowledge the participation of everyone who took part in the research. And we really appreciate the kind of the spirit of this webinar, I guess, working towards that shared vision. So thanks everyone for joining us today. And by all means, follow up with us if you have outstanding questions. Apologies to those questions that we couldn't get to today. Thanks for your time.